The other one is the question that is very controversial, and that is this small committee looked at the question of adopting the American standard in the New York Times and Sullivan case. Mr. Spalding has addressed you very eloquently and cogently on the importance and function of the role of the media. And certainly what one has to be careful of is that we don't have anything that's a chilling effect that prevents the media from carrying out its functions in a free and democratic society. Now, what we find is that the small report had three different approaches. One was that few persons who agreed that the New York Times and Sullivan should have followed. The others who didn't go that far but say that the burden of proof should be reversed. And the third agreed that it should not be changed and that Reynolds produced a satisfactory answer. Now, I would like to start first and say that I do not think that we could say that Reynolds produced a satisfactory answer, because Reynolds has certainly put some burdens, additional burdens on the defendant, more than what existed before. And if we look at what has happened in the Commonwealth, particularly in Australia and New Zealand, they have refused to follow wholeheartedly Reynolds. In the New Zealand experience, the New Zealand court had a situation where there was a political discussion. The matter ended up in Libel and it went up to the Privy Council. The Privy Council referred it back to the Court of Appeal on the basis that it was the same day that they had decided Reynolds in the House of Lords and asked him to reconsider it. When it went back to the Court of Appeal, they examined Reynolds carefully and refused to follow it. The reasoning being that, first of all, they say qualified privilege had been hammered over many years by a lot of judicial precedents, and if you're going to change it, then you ought to do so by legislation, not by judicial activism. They pointed out that what Reynolds did was impose on a defendant a duty of care before saying anything and refused to follow it. The reasoning being that, first of all, they say qualified privilege had been hammered over many years by a lot of judicial precedents, and if you're going to change it, then you ought to do so by legislation, not by judicial activism. They pointed out that what Reynolds did was impose on a defendant a duty of care before saying anything. They also said that before that, there was no duty of care on anybody in qualified privilege. What you had to show is that the occasion was qualified privilege. The occasion, not the statement, that there was a reciprocity between the speaker and the recipient, and not any duty of care. And Reynolds has introduced a duty of care. And therefore, they felt that this had to be done by legislation, and so they refused to follow Reynolds. But they have created a system which is not altogether with keeping with Sullivan. It's a little bit more narrow, but they agree that you could have political discussion and political privileges, but that you had to show that the person acted with malice. And so they didn't go as far as public officials. That was a narrow distinction between the New Zealand and the Reynolds. And then the Sullivan. Sullivan did public officials. The people in New Zealand kept it to politicians and political discussions. The same thing happened in Australia, that the Australians kept it for political discussions, again, not going as far as public officials, which is wider. Now, What we said, if you're going to have a situation which takes it away without any proof, if you don't follow the Sullivan case, like our common law on defamation, there's a presumption of falsity. So once a person sues, it is presumed that what was published is false and malicious. That's a presumption. What's that?
What law establishes the presumption of falsity?
Our common law. And that's the difference between Sullivan and ourselves, the burden of proof. That is a big difference. If you sue for defamation, the defendant has to either justify it or qualified privilege. You have got to prove falsity. That is a big difference. You don't have to prove falsity. And if you read it, you can get all of them and prepare to go to it. You're presumed to be false. That's a big difference. And that is the big difference between Sullivan, is that in Sullivan, the plaintiff under American law has to prove the falsity. That is the question. And that's why others in the small report, the second set, said you must reverse the burden of proof. That is really the issue. Because to succeed in America, what the public official has to prove is false and it is malicious and to affect it. In our jurisdiction, you have not to prove the falsity. You have not to prove it. It is presumed. And I'm saying that if you're going to start off on the constitutional right with that presumption, then it's out of proportion to the protection of the right. Logic would seem to dictate that you have to prove the falsity, and that's not proportionate. That you want to protect the reputation, and the person has published, and you say, certainly, you have published something false and prove it. But here is the reverse, and this is a really big difference. So big difference. And if you look at all the things in the English reports, the Fox report and that, they make this big distinction between presumption and that. And that is why a while ago I said this is like tourism. That is why they're suing in England. They have got to prove anything before the presumption is there. You have got to go and legitimize it. And we say that if you're going to enjoy the constitutional right.
You published it. You published it.
If you want.
You published it.
Yes.
So you must affirm or deny that which you published.
You must what?
You must affirm or deny what you published.
No, but you see, the point about it, you're putting the burden on who? You so and say it's the faculty.
You, the publisher, assume the burden by publishing it, sir.
No. You see, right away, this is a difference. This is a fundamental difference.
But you put it forward as being reliable, as being truthful.
What's that?
You put it forward, the publisher.
No, he doesn't put it forward as being truthful.
He puts it forward as.
There's no presumption of truth.
It has no moral character at all. When I say something on radio,
Yes.
it has absolutely neutral moral character. It is neither truth nor innocent. It is just words. Sir?
If you say something, then certainly, if I say it is false, I should be able to prove it is false. I can't just say because you say it, right? And so it is false. You can't just assume that. This is a big difference, and this I don't think I need to but this is a fundamental difference between the American system and the English system. There are